right, so the other day, agent came to me and they were, another agent was talking to them and they had submitted an LOI for a lease. And that agent mentioned, well, is this person married? And of course, my agent said, yes, they were, because they were. And he said, well, is the husband gonna sign? And well, two things came about from that conversation was, we're located in California, which is a community property state. There are community property laws that do affect liabilities for businesses when it comes to a marriage or a couple that's in there. And when it does that, one of the things when it comes to the community property laws is that essentially under community property states, the liabilities of a spouse fall on the other spouse as well, even business liabilities. So they could, in theory, pass through. Now, the argument for the other agent to get the husband to sign the lease as well is kind of a moot point at this point, because he's saying, well, it's a community property state, so the husband has to sign the lease. Well, actually, he has it wrong. The husband doesn't have to sign the lease to actually still be tied to it in a community property state. Now, there are still reasons to get a spouse to sign a lease as well when it comes to business or commercial leases, because there are ways still to protect your assets in a community property state, and that's what you have to be aware of. So, essentially what business guarantees are passed through from one spouse to the other. There are creditor rights in that, and so that if the one spouse defaults on that commercial lease, the creditor, meaning the landlord, can actually go back and come after the other spouse as well and their assets that they may be holding. Now, protecting it. There are different ways to protect it. Number one being the simplest, maybe possibly putting it in a trust, but it also depends on what type of trust that the assets are held in. Is an irrevocable trust or a revocable trust? Typically, courts look at revocable trusts as not as strong as a protection as an irrevocable trust. In addition to that, timing is a key factor when it comes to trust and when the assets were put in the trust. If the courts, and a lot of courts have a lot of leeway on how trust assets are split up and or divided, or being able to be tapped into for securitization and things like that. And one of the things that the courts do look at is timing. Now, were the assets done, maybe put in a trust before the marriage? Was it put in a trust right after the marriage? Or was it done right when they signed the lease, so to protect their assets? Because if it's just to protect their assets and to hide them, that trust may not be an effective way to actually protect those assets. The court could rule that it was just done to hide them or protect them from a creditor, in which case they may be attached again and gone after by the landlord and or any other creditor. So the trust is one. Now, other way of doing it is prenuptial or postnuptial agreements. Now, these are not necessarily the prenuptial agreement we've all talked about, we've heard about that, but a postnuptial agreement can be formalized in addition to a prenuptial, and what it means is that it is after the marriage, post-nuptial, and it's an agreement that's made between the husband and the wife to divide up the assets, or to basically state that this asset is not part of the community property. So, for instance, let's say a wife is purchasing a property with another partner or an investor, and she's using her own funds or funds that she had generated herself prior to the marriage, or that she had received prior to the marriage, or that during the marriage she even generated her own funds and she's using that, but wants to keep it separate from a community property state. Well, the husband can then come in and sign off on that LLC or the entity agreement, stating that they have no rights to that entity and releasing it to themselves. Sometimes it may be in the form of a quitclaim deed, where even though it's deeded over, then the spouse signs a quitclaim deed or a release back to them, so that only the one spouse actually holds the entity. This can also be done not just with real estate, but also with businesses. You know, so if I'm starting a business up and I'm using personal funds and I don't want it part of the community property, I can create it and have it set up so that perhaps my wife would then sign off and sign the paperwork stating that she has no claim to this business. Okay. Now, at that point, it should be protected. So there are ways to protect it and go around it. In that case, if you're the landlord and if the couple has, and you're in a community property state, and the couple does have these postnuptial or prenuptial agreements, or they have carve-outs where perhaps the assets are not considered as community property but are leaning more toward one versus the other, then the landlord's definitely going to want to have the other spouse sign that lease as well. Okay, if that makes sense. Because, you know, if the assets are broken up and divided out, then the only way to really protect themselves is to have the both parties to sign the lease agreement or guarantee. So now there are certain specifics also within the state that you're in, and you have to be aware of that. For instance, I know California can be a little bit more stringent than many of the other states, including debt that may have been incurred prior to the marriage may be considered as property or community property, and both spouses may be responsible for it. This could be in the form of a mortgage. This could be in the form of a lease that they've taken on, because that is in essence a debt where they're agreeing to an obligation to pay rent for a certain period of time. It can be in many different ways, so be sure that you understand the state laws as well. Some can be a little bit more stringent, some can be a little bit more lenient when it comes to the community property and how they share it and what they go about doing that. So regarding that, the other ways, a couple of the other items, and one touch base on this. You know, you have the prenuptial, postnuptial agreements that we talked about. You have separate property, meaning property that was perhaps purchased beforehand or done beforehand prior to, and of course the state is not recognizing the pre-marriage, such as in California, it has to hit certain criteria for them to recognize it too. In that case, the business can be designated as a sole and separate property versus community property if it was created prior to the marriage. Business partnership agreements. You know, this is what we talked about just a little bit earlier. It's kind of like the postnuptial agreement, but instead of having a formalized marriage agreement, it can be written into the form of the business agreement itself, where the one party waives their rights to the community property laws when it comes to the business entity itself, understanding that this person or the other party is going to be putting the major effort or all the effort into building that business and most of their own money. And again, we talked about trusts, but be aware again, a lot of this is all dependent on timing. And if it gets kind of crazy and dirty and people appointing and trying to go after that community property, you might have to go in and get forensic accountants involved to determine when it was done, how it was done, how the money is being split up, how it has historically been split up, because the courts are going to look at that as well if they ever came to a trust situation of like, well, is this trust a valid means to protect the community property, or is it just created to hide the community property, in which case it's not valid to protect it. So timing goes into it, forensic accounting goes into all of that as well. One last thing on this, and you know, I know this is a little bit short class, we're going to open it up to some questions as well here, but make sure you seek professional advice early on, not after the fact, you know, because structuring your business entities can be done in a way, and should be done in a way, that if you're doing it to protect yourself, that's typically why people create like an LLC or a corporation. Well, if you want to protect the community property as well, it should be done ahead of time. So you want to talk to your professional, whether it's an attorney, a trust attorney, a business attorney, whatever attorney that can advise you on how to structure the business agreements and the business entity documents in a way so that it doesn't convey that they're community property, but rather it explicitly shows that they're not, and then put it in the right type of trust at that time as well. So you have multiple layers at that point by hiring and looking into and working with a professional for their advice. So I highly recommend doing that because it's not just a one and done, and you may think you're protected, you may think you have that shield, but that shield may have some chinks in the armor, so to speak, or some cracks that people can get into. And if ultimately you're really trying to protect your assets, make sure you're done right. There are a couple steps that you have to do that. And as a landlord, yeah, if you're not sure of how a spouse has their assets, if they're not showing the assets, if one spouse shows more assets than the other spouse, then it may not be, it may not be community property. You may want to get both spouses to sign that lease agreement or the business agreement or whatever agreement that you're working on, so that both of them are now bound to it. Either that or ask for clarity and get that clarity. Something in writing, something showing that the assets of both parties are actually community property and they haven't been bifurcated into separate property. Okay, so any questions?
If, say my client's keeping everything separate,
Mm-hmm.
and the client has all the business, all the mortgage, everything is in their name, and their spouse has
Mm-hmm.
essentially nothing.
Mm-hmm.
What's the would there be any requirements for the spouse on the lease?
Well, just because one spouse has everything in their name and the other spouse doesn't have anything in their name doesn't mean that it's not community property. So under the California laws or under community property state laws, it could still be considered as community property just by having title hold it. Now the difference is, and again, this goes back into setting it up, meaning when you say everything is separate, then all the business operations should be separate 100% with bank accounts. There shouldn't be any kind of commingling of funds. If she uses, or if the client uses that bank account to pay personal obligations that are both the husband's and the wife's, then that whole asset, that bank account may be considered as community property regardless of how it was structured. So really it's not just a factor of structuring and protecting it as in one person's name or not, it's actually having the additional structures such as an irrevocable trust, such as the prenuptial and postnuptial agreements. Just because they put everything in one person's name doesn't prevent it from becoming community property. It is still going to be community property unless there are those agreements ahead of time. So, and even if those agreements are there ahead of time, if there is commingling of the funds, the assets, you have your personal account is the same as your business account. Well, you can't argue then that your business account is separate property versus your personal and community property. So it also it matters how you're conducting your business, because the courts always tend to lean more toward if it's showing that you're really looking just to hide the assets, but you haven't taken the steps to protect the assets the appropriate way, then the court's going to lean toward, well, you know what, they're still community property assets. So in that instance, the question is whether or not, do they have prenuptial or postnuptial agreements? Because if they don't, and or irrevocable trust, if they don't, then there's a good likelihood that it's all community property that that client has.
And the landlord would request signature from both.
Landlord may request signature from both just to protect themselves, just because the way that they're holding it, and they don't necessarily have the clarity or the vision of exactly what they've done. So they may ask for both parties to sign. That being said, it wouldn't actually be necessary if, unless it was actually separated into separate property versus community property. Landlord wouldn't even have to have them sign. And if I'm representing a tenant in that situation, and I know that it's really all community property or so, and that's been told to me by them, and whatever, an argument back to the landlord is, you actually don't need both parties to sign, because in a community property state, their assets are combined and you can go after both of them. The landlord can still go after the husband or the wife or the other party in that situation and name them in that lawsuit.
So whether they sign or not, because they don't have prenuptial agreements or trust set up to protect and split everything,
If they haven't
they're
taken-
liable anyways.
Absolutely. Well, if they haven't taken the steps to protect the assets appropriately by putting them either having the prenuptial, postnuptial agreements, or putting them in irrevocable trust and separating out the accounts. Also, remember, all that has to be done. So if they haven't been doing all of that and it's not that, then it's all going to be community property, regardless of whether the person signs or not. So, unless they've taken those steps. So, and in reality, as a landlord, then I would not need to have both signatures. I may want both signatures just for ease of clarity and things like, for instance, I don't have to prove then that it's community property if I'm the landlord. So I would ask for 2 signatures. I mean, it's just an additional step. Does it protect me more? A little bit, perhaps. Does it? But ultimately, in this situation, is it going to change anything? Probably not. So, other than the fact that it may make it more expeditious. Meaning, if I were to go after one party and go after the other party as well because they defaulted, the other party may claim that their property is sole and separate property versus community property, and then I, as the landlord, have to prove or show that I would request proof and for them to show that it actually is separate property versus community property. And if they can't do that, and go back. So that's additional time and layer and cost in chasing the money. Ultimately, is it going to affect the bottom line or the end of the game? Probably not. You're probably still going to be able to win the case and go after the community property assets. It's just going to delay it, and it may cost more money. That's why a landlord may ask for both parties to sign, just to be safe.
Okay. Would you ever want, is there ever a situation where you don't want multiple signatures, where you want, like one spouse has a lot of debt and then the other spouse doesn't, and they've kept it separate, and then you wouldn't want the one with the debt on the lease?
Well, I mean, this is where the forensic accounting comes into play. When you say that, because it's a red flag when one spouse has all the debt and the other spouse doesn't. And the main reason it's a red flag for that is it typically is, they're using one spouse as the person to go in because they have no debt. They may qualify for something more, but then everybody is saddled with the huge debt. Now, the question then would come to in the forensic accounting side is, how's that debt? What's that debt for? What was it used for? Is that debt, does the other party have any benefit from that debt? I mean, if it's a credit card that's used for community purposes, purchasing things for both of them, for the family, for the house, for the household, it may be considered as community debt, and they could go after that person, the other person as well. So in that situation, it's a matter of how that debt's being used. Also in that situation, yes, I probably would require, or if I'm the landlord, require or request that both parties sign, just because I know that they are already taking steps. Whether or not they did it the right way and appropriate way, it's a red flag as a landlord because they've taken steps to hide things and or move things around. And as such, since I don't know all the mechanics and all the agreements, and the last thing I want is for them to come up 3 years down the road, oh no, they signed this prenuptial beforehand, it's notarized, and this is not part of it. So in that case, if I'm looking at it and I'm seeing that they're separating these assets and trying to hide things, I may require both of them to sign, depending of course on what the assets of one versus the other look like as well. If I have someone with very strong assets and showing community property, and if it's perhaps the person signing the lease is the one that's on title to the house that you mentioned that they have a loan on. If that's the case, they have assets, they have equity. may not be as important to get the other party to sign if they're not the ones holding all the assets. It depends, so, in answer to your question, as a landlord, we like safety and clarity, so we try and get everybody to sign. The more people you can get to sign and guarantee, the better it is for the landlord. On the tenant side, however, the least amount of people in the guarantees that you can get for your tenant, the better it is for them, just in case something were to happen down the road. So it's unfortunately not a straight answer, but it's a matter of what does it look like in the big scheme of things? How are they doing things? What are they doing? But also it's perception. Understand that even if they haven't done it right, it's not really a valid argument to say, it's not in a, yes, it's all separate, but it's really community property state, because, as a landlord, they're not gonna accept that. They're just gonna come back and say, I still want them to sign both of them to sign if they want the space. Because this person doesn't have enough assets, she needs another guarantee, or he needs another guarantor. And it needs to be the spouse, however it may be. So it really varies, and it depends on the whole big scheme of things, but it's not necessarily a valid argument to get someone not to sign. However, if the assets are in one person and they're the one signing, then you can come back and say, the spouse really has no assets. All the assets are with the person signing the lease. And in that case, they might be, and if they can actually show it, that that's the case, and it makes sense, meaning when they're showing their assets, they're filling out the application, they're showing that they have, the mortgage in their name, the house in their name, the title's done, it's not homesteaded, it's not hidden, it's not in a trust, things like that, then a landlord may be okay with accepting one of the parties signing. So.
How do you verify who owns what in the trust? If you see the owner of the house is a trust, what do you ask for to verify who owns that, and is there like some type of document that you would request, or what type of, how do you verify all this, who owns what up front? And
Well, there are public records that show who the actual ownership is, and if the ownership is in a trust, it's typically a lot of times the public records will also have the trust, but also the trustee's name on there as well as the secondary owner. Typically a landlord, if they get and want to delve into it and they're really looking at the granular details of that, they may ask for the trust document to make sure that the person is part of the trust and that it's not set up as an irrevocable trust that's just in one party's favor, things like that. That's the only way to verify it. Now you as the broker, because whenever you say, how do you verify? You as the broker don't do that. Okay, that is up for the underwriting of the landlord. That is a property manager's job. That is the landlord's job if the landlord doesn't have a property manager. They're the ones who make the determination of whether or not to extend credit to this potential tenant, essentially extending the credit for the 5-year term or 3-year term or whatever else of the lease, and decide to lease it. Now, that's something that the landlord has to decide based upon a lot of different influences and factors. So it's not up to us to make that decision for the landlord to accept it in this case, and nor is it up to us to verify this. This is for the landlord to ask, get the documents, review it, and verify. Okay.
Good.
Any other questions? All right. Well, thank you all for today's class.